Well, Your Lordship, I'm respondent number 9 in item number 1, Your Lordship, I have filed an affidavit in opposition. That is not in record, Your Lordship. By this requisition slip, Your Lordship, I pray that may be brought into record.
May it be the Lordship. My Lord, item number 2. My Lord, I am ready, my Lord. If Your Lordship wants to take it, I am doing, my Lord. But only in page 27 of the review application, I found, my Lord, once upon a time, Your Lordship appeared for the education department.
We'll look into it and then we'll pass the order. Okay. Okay, to number 2.
Page 27, my Lord. If Your Lordship willing to take up,
No,
I have
let
no.
us see. Let us see. Somehow, if I have entered into, I know the records, so definitely.
Page 27 of the review application. Bottom portion, my Lord. Otherwise, I am willing to do it now.
Better not to take.
My Lord,
Better not to take.
I
So I
would,
don't remember anything, but better not.
but otherwise, my Lord, many of the cases of education department, Your Lordship name it.
We'll see whatever is there, we'll take it, otherwise we'll not take.
Parties are ready to place it, only if Your Lordship willing to take
Doesn't
up.
matter.
But this order is not under review, but subsequently the order was passed in pursuance to this judgment of Justice Amitabh Raj. Justice Ujjwal Bhuiya's order is under review.
But Lordship, all are connected matters. Lordship will find at page 33, paragraph 2.
No, I'm still there.
Though here Milord mentioned that the state government has not abstained from the participating in the proceeding. Lordship probably, perhaps Lordship appeared on behalf of state. Even though Milord,
But is only a formal party.
Place this matter before any other bench.
Obliged.
May I please, Your Lordship. Lordship, this petition has been filed for compensatory ground, Lordship. And petitioner's father has died on 1st January 2007, Lordship. And he has applied for this LD assistant post on 31st August 2007, Lordship. And DLC Nalbari has not recommended his name without any reasonable ground, Lordship. And Nalbari recommended the respondent number 13, private respondent. His name has recommended, Lordship.
Mr. Pegu, at this stage, will you able to get this the reason for rejection of the petitioner's case for compensation?
That private respondent who was appointed, considered, my lord, that economic condition of that private respondent was.
Lordship.
No, we'll see, because if there is certain comparison, if it is found that the PLC have rightly rejected the case of the petitioner, then we will not look into it. So if the service of the private respondent is required to be disturbed, then only we will call. At this stage, it is not required. Okay.
We'll get the instruction then.
In other hand, Lordship, item number, respondent number 13, economic condition, Lordship, petitioners better, Lordship. This,
Who's better? Petitioner is
Lordship, respondent number 13, Lordship. Petitioner, poor
Yes.
person, Lordship.
petitioner is a poor person.
Yes, Lordship.
What is your educational qualification?
Lordship. আমার education qualification. তোমার financial.
He is from Nalbari district, my lord. Short date, my lord. I'll get a
Kamu bisa tuh kan? Pokoknya nggak mau aja. Boleh datang dulu.
RMS J. Colita, counsel for the petition of
Aku dapat komplek. Jangan nih dapat komplek.
and Mr. T. Pegu, Government Advocate Assam for testimony number 1,
5 and 6.
5. Also heard MS T. Musala, Understanding Council, Department of School Education. For the respondent numbers 2, 8 and 9. As well as Mr. A. Chaliha, Standing Council Finance. For the respondent number 3, 10 and 11. Other of the petition. While serving the lower division assistant in DPB Milon High School, District Nalbari, died in harness on 02/01/2007. The petitioner submitted his application within time for consideration of his case for compassionate appointment under the Diane Henry scheme.
Nah.
His case was not placed
Solution lagi.
before the DLC
Proposal.
Nalbari. However, pursuant to the orders of the court, the 01/08/2007,
Itu yang aku beri dapat.
passed in WPC number 3866/2007, The DLC Nalbari. This case was placed before the DLC Nalbari. For completion at one. But disregarding his better claim, say DLC Nalbari. When he was WPC number 3105, order is 3105. Where is the minute? Madam Kulita, where is the minute?
Lordship,
When it was rejected,
Lordship,
on which date?
24/1/2011. Page 29.
Right. 24/01/2011. Rejected the case of the petitioner. Only. Consider the case of the respondent number 13 and recommended his name disregarding the better claim. of the petitioner. Being aggrieved, petitioner has presented a petition on 18/07/2000. The Deputy Commissioner come Chairman PLC Nalbari as well as the additional Deputy Commissioner Nalbari. Respondent number 5, numbers 5 and 6. As well as the Inspector of Schools Nalbari, respondent number 8. On the next date, we shall apprise the court the reason for not considering the case of the petitioner for his compassionate appointment. It's meeting held on 24/01/2011. Copy of this order to Mr. P.P. Mohammed Batam as well as MS Musab. List on 28.
Otherwise, my lord, there were 20 proposals, 20 vacant posts. 5% will be one post, my lord. So out of the 20 proposals, only one was
No,
considered.
has to be some reason.
My lord.
This shall reflect a name of Sanjeev Hazarika, Planet Council for the respondent number 13 in the call list.
okay.
Lordship, it may be taken off sometime because Miss Terangpi was here. She had to go, Your Lordship, get the instruction. After some time, Your Lordship.
Review petition number 72, your lordship already heard my lord, my senior argument. And, regarding mine, another WPC number 98W 2002, my learned friend appears, and your lordship directed to make a party. And this implemented respondent, I have been filed Ukalatma for respondent number 9, implemented my for the bishop. By earlier order, your lordship directed. Item number 7.
Private service report on the respondent number 8.
And my lord, in this seat petition, we have already taken this.
This we have to go up. Steps taken very recently, it has been only 2 days back.
Yes.
Private service report to respondent number 9.
My lord, we already got the notice from this honorable court also, my lord. And accordingly, I have
Placed
filed.
on. Twenty-seventh of April,
27.
because just left on 27.
Yes, man, no.
There are many vacations are there.
Right.
So after all the vacations, we have taken to 20.
Well, all the matter.
Well, I am applying for the item number 5, my lord. Review petition number 8522, my lord.
Review petition 85. Review petition 72 along with application number 98.
Lordship,
Yes.
May I
Why we have
please, Your
prepared
Lordship?
this review?
Lordship, the order that is under review is at page number 26, Your Lordship.
Hmm. is the reason for preparing this?
Lordship, Lordship, what had happened was that on 10/5/2018, Your Lordship, an advertisement was published, Your Lordship, on 10/5/2018.
Yes.
It was published by the Assam High Secondary Education Council for filling up 31 posts of junior assistant posts, Your Lordship. Then on 16/9/2018, the written test was conducted.
Total post,
31, Your Lordship.
then
16/9/2018, the written test was conducted, Your Lordship. And then on 15/2/2019, results of the written test was declared. Then, Your Lordship, on 18/2/2019, computer test was held, Your Lordship. Then on 13/9/2019, Your Lordship,
13th of September,
13/9/9,
3013,
September, Your Lordship.
3013.
13.
Okay. Then what happened?
13/09/2019, Your Lordship. We had actually received a complaint, Your Lordship, which is at page number 16, Your Lordship. Office of the Commissioner and Secretary, Education Department had received a complaint, Your Lordship, in connection with the selection process, Your Lordship. The complaint was that the chairman of the Assam High Secondary Education Council had made phone calls to the principal of the Pandu College, Your Lordship, requesting him to make arrangement for putting the signatures of the invigilators on the day of the invigilators on the day who were appointed on that day, Your Lordship, on the OMR sheets of 2 candidates. So, so the complaint was that, Your Lordship, and that complaint was forwarded to the secretary of the council. Then on 7/12/2000,
Basically, what you found that in 2 of the OMR seats,
Lordship, the signatures were not there.
signatures are not there. It's
Not
blank.
there, Your Lordship. So the chairman of the council had requested the principal to put the signatures on those OMR sheets, Your Lordship. The invigilators who were on that day appointed on the day of the examination on the OMR sheets, so it was requested to put the signatures again, Your Lordship. So that was the request made by the principal, Your Lordship. So they refused to give the signatures because what they say is that they were there on that day and signatures were put. So again, putting those signatures, so they thought that there was some problem with the
Now, tell us whether those 2 particular OMR seats,
Lordship.
one of the OMR seat was the petition.
Petitioner, no, Your Lordship.
is not.
Some different candidates, we do
So
not
at
know.
best what? You have to remove those 2 OMR seats.
Lordship,
And other candidates whose signature are there in that area, respective
Lordship,
OMR seat,
Lordship.
that could have been taken care of.
Lordship,
That doesn't mean the entire process is bad. See,
Lordship.
normally what happens? When you cannot remove the chip from the grain,
Lordship,
right, then it is possible.
Lordship,
The law laid down by the apex court in 2 things. When a particular selection process can be checked,
Lordship,
apparent illegality in
Lordship,
the entire selection process.
Lordship,
Secondly, when the selection has already been done and there is a marks, there are a large number of complaints,
Lordship,
then it is possible if it is saying that for those candidates, it is you can remove the chip from the grain, that for those candidates, it will not be
Lordship,
disturbed. But for others,
Lordship,
and when the entire selection which thinks a lot,
Lordship.
then entire thing will go.
Lordship, that is what, Lordship, because then after the inquiry was conducted, Governor of Assam directed the chairman of the
have it
council to
now.
conduct an inquiry. And in that inquiry, Your Lordship, serious irregularities were seen, Your Lordship. And there it was also disclosed in the inquiry report that proper records of evaluation of the candidates had not been maintained. And also, Your Lordship, actually,
OMR 6, what is the issue? OMR 6, that is why you do. In the OMR
No,
6, there is
the-
nothing like that.
Lordship, what had happened here was that when this, the writ petition was heard on that day, Your Lordship, these facts were not placed.
We have already observed if there is no other impediment in doing the
Lordship, it's
same,
had,
then
Lordship, it has been observed, Your
So-
Lordship.
the office should give the reasons.
Lordship,
You need not prefer a review in abandoned caution.
Lordship. Lordship, actually, Lordship, what had happened was that in the meantime, Your Lordship,
Because after issuance of the notice, what we have noticed that the respondent authorities did not file any affidavit in the matter,
Lordship,
right? So you give the reasons,
Lordship,
what you should do, since you have a handle
Lordship,
to operate, you give the reason. If that is the reason somebody challenges or contempt petition is there, you, give,
Lordship,
right?
Lordship,
Then you say that,
Lordship.
but before cancelling it or before doing anything,
That, yes, yes, Your Lordship. That view was given, Your Lordship, here.
you need not comply, then don't comply.
Lordship,
Since this observation of the court is already there,
Lordship. If there is any impediment, then Lordship,
so what is the reason you are not doing it? You have to give the reasons for which the result cannot be declared.
Lordship, Lordship,
But you have to give a valid reason. That reason will be always challengeable in the court of law.
Lordship. Lordship, our prayer was that, Lordship,
Just
what we had prayed is that Your Lordship Lordship may hear the matter again, Your Lordship, to restore the WPC 4859, in which Your Lordship had passed the order to restore it and to hear it again, Your Lordship. কিন্তু order মানে review টা কৈছে এইটো ইয়াতে মানে already court কৈছে if there is no other impediment in doing this তেখেতে মানে কৈছে যদি problem আছে then you give your reason you say that এই মানে selection process আমি declare কৰিব নোৱাৰো, we cannot participate. So এখানে এইটো review নকৰিলে হ'ব।
please take your seat.
Lordship. I don't know.
But there are many other petitions.
Lordship. Lordship, those petitions were withdrawn, Your Lordship. Lordship, Lordship. But itu apa na? Technology ko. 21 days. Ito to 21 ata. 21 ata. Mga tanong ko. Ito tayo sila ata. So,
274. Okay. itu boleh. Tapi itu. Not MSD Mutahari, council appearing for the review petitioner. This review is against, this review petition is against the order, is for reviewing of the order dated 04/02/2021, first in WPC number 4859/2020. Within bracket লিখিবা নীলোৎপল ভট্টাচাৰ্য versus State of Assam and two others. Setting the regions as to why the process of selection to the post of junior assistant, 31 numbers of junior assistant in the office of the Assam Higher Secondary Education Council, advertised on 30/05/2018. Advertised on 10/05/2000. Comma, published on 11/05/2000. And to declare its result pursuant to the order dated such and such in said WPC number such. Issue notice returnable by 4 weeks. Petitioner shall So copy of this civil petition, Mr. P.C. Sutia. That's the D. Roy. Any council. Assam Higher Secondary Education Council. Obtained within 1 or before. 9. Obtaining statement. Petitioner shall take steps for service of notice on the response number 1 by raising the report by the honorable.
I have received an instruction, Sir Lordship.
During the deliberation of the matter, it is placed before the court that pursuant to the order dated common order dated 0109/2016. The state government in the secondary education released an amount of rupees 6,32,35,824 for payment of arrear salary to 4 numbers of 6,32,35 লিখছে না তার আগতে একটা sentence. That is Department of School Education. Released an amount of rupees 6,32,35,824 to 4 numbers of junior colleges with effect from 01/02/2001 in compliance of the order dated 31/01/2019 passed in read appeal number 158/2017, linked with read appeal number 229/2017. Arising out of WPC number 924/2012 and excluding Baska Junior College, Baganpara District, Paksa, that fall under the jurisdiction of BTC authorities. It is also placed before the court that the state government on 09/02/2023 and 01/03/2023 communicated to the Director of Education, Betty Pokratar, in that regard, and to place the report of releasing the amount payable to said Paksa Junior College while it was the deposit system of Branson 8. As such, the prayer of the petitioner number 2 and 3 have already been complied with. As such, the respondent authorities have complied with the direction issued pertaining to the petitioner number 2 and petition number 3 junior colleges. Place this matter on. Can you have Mr. R.B. Bora or anyone from the standing council BTC? If anyone standing council BTC is there, we will pass necessary order. Wait for some time.
Your Lordship, I am for the respondent number 9, Your Lordship.
Who's for one petitioner?
Petitioner, his junior was there, Your Lordship, in the morning time. Your Lord.
Mr. Burwa, you will appear for BTC? You will. See what has happened during the direction of the learned single judge, it was upheld by the Honorable Division Bench in two particular read appeals. So for payment of their grants in aid from the year 2001. Now, what happened with regard to the other schools which is outside the jurisdiction of the BTC? For it, the Department of School Education has released that amount, more than 6 crores and all. Now, only with regard to one particular junior college, now senior secondary school, Baksa Senior Secondary School, that is to be paid by the authorities in the BTC. Communication was made in February, also in 1st March, 2nd of February. So we'll fix a date and let us know. Just give him the two communications so that they can take up the matter. It was communicated to the Director of Education, BTC. So give us a date when you
We will fix it after 10 days. In the meantime, get the instruction.
will give us a date that should be
Let it be on 20th February, my lord.
20th February.
28 March.
Sorry, 20 March. Sorry. तो कॉपी मुख लगी है
On the next week. Director of Director of Education, BTAD Koprajar, shall apprise the court about the status of compliance with the order dated 31/01/2019, passed in read appeal numbers 158/2017 and 229/2017 regarding the payment of the amount of deficit financing system, deficit financing aid to Baksa Junior College. Baganpara, District Baksa. It's on 28th of March.
What will reflect the
Reflecting the name of pending council PTC. Communication dated 9/02/2023 as well as 01/03/2023 of the state government APS school education. We kept as a part of that.
those two documents, lordship will have a photostat copy of this communication, my lord.
Do you have a copy? You don't have? Oh, you okay, to be given to you.
Not.
To be given. Yes, Mr. Khatania, this is with regard to appointment of a junior assistant in Rupohi Senior Madrasa in district of Nagaon, way back in the year 2015. The two things what they have said is that the select list was not published and the appointment was made without the approval of the government. That much only is required. We'll see where, if it was approval was given, then just to verify.
Yes.
Not basis. Now, old matter, 2016, hardly will take few minutes if you sincerely go to the records.
Yes, ma'am.
When
Monday, ma'am.
Monday is a holiday.
Monday, ma'am.
Monday ke tarikh.
Yes, yes.
Is it holiday? Sorry, your
On
lordship.
9th.
On 9th, I will not be there.
And?
Then after 14th, 14th.
On 14th or 15th, madam.
Fine.
My friend is not available.
Will have it on 14th.
Maybe your lordship. 14th, maybe 15th, your lordship.
No representation on behalf of the petitioner.
Mo copy total ito ang ating
What Mr. N. J. Khatania,
So,
counsel,
sorry ba?
Trendy counsel, Department of Tourism. Group Motivation numbers 2, 3, and 5, as well as Mr. T. Ahmed, and counsel. Respondent number 9 has filed an affidavit today by serving a copy of the same counsel copy. List on 14th of March, enabling Mr. N. J. Khatania, the Council Department, to place the relevant information as well as the records regarding the selection and approval, as well as selection, approval, and appointment of the respondent number 9 to the post of junior
I
assistant.
beg pardon of your lordship, your lordship. Nowhere in the act, your lordship, I didn't find that the approval from the government is required.
In the record, the appointment of the respondent number 9 as a junior assistant. The Rupohi Senior Madrasa. Rupohi district. Pursuant to the advertisement dated 08/12/2015 issued by the Director of Madrasa, Director of Madrasa. Because Madrasa education is no longer
No longer
Yes,
there,
so-
your lordship.
Madrasa education, which is now under the Director of Secondary Education.
Yes, your lordship.
Lordship, on the last occasion, your lordship had asked. I flagged it.
Borua.
$14 advertisement. Open to qualified now. Open can get challenge scripts.
Now just tell us one thing. Whether the respondent number 5 has been made a regular headmistress of the school.
Lordship, as far as through telephonic communication, Your Lordship, what they have said is that it's a regular appointment, Your Lordship. regular headmaster, Your Lordship, headmistress. Lordship, if Your Lordship permits, I just want to point out one thing, Your Lordship. Lordship, at paragraph 2, Your Lordship, the petitioner has stated, page number 5, Your Lordship. There he has stated that she had obtained her BS degree in the year 2014, Your Lordship. And her BS certificate is at page 21. There it is, the year is 2014, Your Lordship. And the advertisement was issued on 2/11/2010, Your Lordship. So the petitioner was not qualified on that day, Your Lordship. Because the required qualification is BA, petitioner is supposed to have BA. So she was not qualified, and in that case, Your Lordship, whether the petitioner has a locus,
I have also taken that plea in our application.
because Your Lordship, at best, what can be, what co-warrantor petition can be only issued in this case, Your Lordship.
Just.
Lordship.
Please take your seat, ma'am. Not MS. David. Counsel for the petition.
I may be allowed some time to let's say, take instruction, let's say.
I don't think so. See, madam, please come to page number 21.
Let's see. Let's say,
Are you there in the page number 21?
petitioner was not allowed to go on deputation,
No,
let's
that
say,
doesn't
that is
That is not the issue. Please come to page number 21.
That's it.
This is an advertisement issued on 2nd of November 2010. Now just see page number, the paragraph number 3.
That's it.
Now required to submit application within 28th of November 2010. Right?
That's it.
And this is for, no, page number 20. This advertisement is has to be within 2011, 2010. Now come back to page number 22. Para 3. Again, you will see last date is 2011, 2010.
That's
And in the para 3 itself, you will see should be BT and BEd. Okay. So on the date of filing application, where last date was 28th of November 2010, the petitioner was not eligible for this post, accepting the break-in service. There is nothing to show that the respondent number 5 was not a BEd degree holder at the time of filing of her application for the post of headmaster.
That is not the allegation. Let's
Only thing is the break-in service.
break-in service, and her service book was maintained by herself. Let's
No, no,
say. That is
That's
also
true,
another
but that has
allegation.
to be always verified, right?
That's it.
That will be verified. As she is the drawing and disbursing officer, as she is the head of the institute, definitely. But it has to be approved by whom? By the inspector of schools.
Let's
And inspector of schools, how he will approve? Only on verification of records. First of all, will come the question of eligibility.
the short date will be given. Let's say.
Why? Will not come, madam. First of all, you have to prove your right. Mr. H.K. Bushra, learned counsel appearing for the MS. T. Musahari, learned standing counsel, Department of School Education. For the respondent number 1 to 4. And Mr. H.K. Bushra, and counsel for the respondent numbers 5. Both. And the petitioner and the respondent number 6. Where the teachers of Vidyadhar Sharma Memorial High School Jorhat, provincialized school of the state. Where the petitioner was a Hindi teacher and the respondent number 5 was an assistant teacher. The said Vidyadhar Sharma Memorial High School was later amalgamated with Jorhat Vidyarthi Vidyalaya, where the Jorhat Vidyarthi Vidyalaya is the base school. Was amalgamated pursuant to an order dated 30/03/2022. Issued by the Director of Higher Education, the Director of Secondary Education, after approval of the state government in the secondary education department. Before such amalgamation of such and such Jorhat Vidyarthi Vidyalaya, the response number 5 was serving as a headmistress of said Vidyadhar Sharma Memorial High School, whereas the petitioner was the assistant headmistress of the said school, the same school. On being recommended by the selection committee constituted by the government by notification dated 10/12/2010 and 25/12/2010, and on being approved by the state government on 07/07/2011, the Director of Secondary Education Assam promoted the response number 5 to the post of headmistress in Vidyadhar Sharma Memorial High School, Jorhat, by order to pursuant to the said order of the DSC Assam dated 2011/2022. The response number 5 immediately joined her service as a headmistress of such and such on being promoted by the order dated such and such. The petitioner, being aggrieved with the appointment of the respondent number 60 as the headmistress of such and such high school by the order dated such and such by the DSC Assam. Filed this writ petition on 29/02/2016, challenging her said promotion to the post of headmistress of such and such high school. Alleging that the respondent number 6 had break in service as out of the total period of her leave of 74 days, the inspector of schools have cancelled 37 days. The respondent number 5 and 6 have filed their respective affidavits in the matter. There is a joint affidavit. Clarifying that though the petitioner alleged that the inspector of school while considering and granting unleave to her on medical ground under rules 13 within bracket small h within bracket small 1 of the revised rules of 1934 as amended for a period of 74 days by the annexure H to the writ petition, but stating that the 37 days leave has been cancelled, etc. But placing a copy of the order of the inspector of schools, Jorhat, issued under memo number PRGH-leave /PT /09 /50/1748-51 dated 13/01/2011, annexure R4 to the affidavit in opposition of the respondent numbers 5, 6 stated that there is no such observation of the inspector of schools, Jorhat, that 37 days leave of the said respondent number 6 had been cancelled. On perusal of annexure H on the writ petition, on the basis of which the petitioner claimed the break in service of the respondent number 6, as well as the copy of the order 13/01/2011 of the inspector of schools regarding granting of leave to the respondent number 6 on medical ground, annexure R4. It can be seen that the Annexure H annexed by the rate petitioner is without any signature of the Inspector of Schools, Jorhat, and without issuance, without any memo number and merely a typed copy. Whereas Annexure R4, the affidavit in opposition of the respondent number 5 and 6, the copy of the order dated such and such, the Inspector of Schools, which too doesn't bear a signature. Bearing signature of the Inspector of Schools, Jorhat, it was forwarded to the headmaster of such and such. EPS memo will attach. In the read petition, the petitioner has annexed Bachelor of Education Pass Certificate number 1400993 issued on 02/01/2016 by the authorities of Dibrugarh University. Annexure E to the read petition, which goes to show that the petitioner qualified her B.Ed degree from say Dibrugarh University in the annual examination held in the year 2014. The petitioner has also annexed the advertisement dated 02/11/2010 issued by the Director of Secondary Education Assam, some member secretary of the State Selection Board, wherein amongst others, advertisement at serial number 3. Advertisement was made for the post of headmaster, headmistress, superintendent of high school of the high madrasa schools. Observing that the post shall be filled up by promotion from the school-wise seniority list of assistant teachers, and the selection shall be based upon seniority and satisfactory annual confidential report for 3 consecutive years, and the minimum qualification shall be graduate in arts, science, or arts with PT/B.Ed degree, having at least 10 years of teaching experience in graduate teacher, specifying that the intending and eligible candidates as per prescribed qualification may submit applications along with relevant documents, public papers in support of their candidature to the respective inspector of schools within 2011-2010. By the said advertisement, the Director of Secondary Advertisement dated 02/10/11/2010. The Director of Secondary Education Assam also clarified that all the posts advertised shall be filled up as per the provisions of Assam Secondary Education within the provincialized service. Petitioner herself contended that she obtained her B.Ed degree in the year 2014, and the respondent number 5 was selected on being selected, was promoted to the post of headmaster of such and such high school. In terms of her selection, pursuant to the advertisement dated 02/11/2010, where the last date of filing application was 20/11/2010, and at that point of time, petitioner was not at all eligible to apply for the post of headmistress at the St. Vidyadhar Memorial High School. As he didn't have the B.Ed degree on or before 2011/2010, the last date of submission of application, where they had obtained the same B.Ed degree only in the year 2014. Do petitioner and the respondent number 5 and 6 in their petition slash affidavits plus rejoinder, etc., have made allegations against each other in their service. But apparently, without going to those aspects, it can be seen that the petitioner was not eligible for the post of headmistress at St. Vidyadhar Sharma Memorial High School, Jorhat, in terms of the advertisement dated 2/11/2010, on the basis of which the respondent number 5, being eligible and on selection, was appointed as the headmistress of the same high school. According to this petition,
Lordship, may kindly peruse Annexure I, Lordship. That may be also included.
Annexure I.
Lordship.
Yes,
Lordship has mentioned about Annexure H and Annexure R4, Lordship.
you
Along with
lodge a
that-
complaint to the government
No.
in the service.
Lordship. That may kindly be.
We will not any observe. First of all, you have challenged her appointment as a
That's-
promotion to the poster after how many years? Her promotion was in
That is
2014, 11, and you have filed when?
I beg pardon of your lordship.
Just a minute.
Your lordship, in item number 1, date has been fixed on 14th, your lordship. 14, I'm having some, your lordship, in Aminda, your lordship. Can it be on 15th, your lordship, if possible? 15th or 16th, your lordship, any date, your lordship. Oblige, your lordship.
Notify করা হয়নি? Hearing list. প্রথম 5টা দিও। নহয়, হেৰি আৰু মোৰ মাজত ভাগ হৈছে নেকি? Leave it for any other appropriate plans without me. প্রথম order করতে পারতে মন না। Mr. Patnia, these are the cases where they should look into,
Yes, ma'am. This is 2009 matter.
not that all illegal appointments. Can you tell us what happened exactly with the Sipsagar method?
But regarding the illegal appointment of Sipsagar, madam.
Access, all are illegal because
madam.
the concerned inspector of schools and the concerned DI, DEO, they have made access appointment.
Yes, ma'am. All are subjected to that screening committee, madam.
Now, what happened? The screening committee.
Screening committee, ultimately the cabinet took a decision. Whoever in the service, they're continuing their job, my lord. The cabinet took a decision to accommodate them as a tutor, my lord. If they have the required qualification, then teacher or otherwise tutor in prospective effect from 1/12/2022. They have been given fresh appointment.
One thing, tell us whether any such illegally, because all these rules 409
Yes, madam.
or frame under an act,
Yes, madam.
so having statutory, cabinet can do that same by taking any such decision. See, we have seen that case from the what Mohanty,
Mamta Mohanty.
there the Honorable Apex could have
Yes.
clarified
Yes, madam.
what is required to be. Now in Uma Devi also you will see that if you See, this is, I don't know who has apprised the government to do that. There's a specific observation. A three judges and judgment in the case of Umarani versus Register of Cooperative Society. That is one of the most important consideration in the case of money. There, this particular aspect was looked into,
Okay, madam.
and the I don't know whether it has been consulted with the there in the Umarani, you can note down the judgment 2004 7 SCC 112. Now, the authorities exercising their power under 162, that is cabinet.
Yes, sir.
There at paragraph 23, it says a bare perusal of the aforementioned provision would clearly go to show that the impugned government order could not have been issued by the state in terms thereof, as the same can be taken recourse to only for the purpose mentioned therein and not for any other. It is not a case where the government directed register to make an inquiry against a person in the public interest. Article 162 of the Constitution of India provides for extension of executive power to matters with respect of which the legislature of the state has power to make laws. Article 162 of the Constitution, by no space of imagination is expected to be source of the power of the state to pass an appropriate order.
Must be traced to the provision of the act.
As for the matters in respect of which the legislature of the state has power to make law.
Yes, madam.
Article 162 of the Constitution, by no stretch of imagination is accepted as the source of the power of the state to pass an appropriate order, must be traced to the provisions of Act itself. If the state had no power to issue the same government office memorandum number such and such, the same must be held to be nullity. Now, that there are 40 or 45. There are 45. Of course, there are other 40 to 43 discussions are there.
Yes.
No regularization is thus permissible in exercise of the statutory power conferred under Article 162 of the Constitution, if the appointments have been made in contravention of the system.
Clear observation, madam.
In spite of such observation of the Honorable Apex Court, how the state government can take a decision? Clear mistake.
Yes, madam.
Are the state is mightier than the law?
No, madam.
Where from they had that power when this power is a nullity? Mr. Khatanya, that is what you are expected to do. You are expected to do it that whenever there is an order which is violation of any law, the law laid down by the Apex Court, your duty to place it before the court. You may be a standing counsel of a department. You cannot
Yes.
hide it.
Yes, madam.
That itself shows the reflex.
Yes, madam.
You should not be hand in gloves with such action. If any order is illegal, you should place it illegal.
Yes, madam.
Don't try to defend these orders. That indicates something else.
Yes.
Remember, that indicates something. Now you have seen this order. How come the state government has that power? The illegal teachers not being selected, access against selection, whatever.
Yes.
Here is a case, this particular matter considered to be irregular. In spite of that, the Honorable Apex Court, three judges bench have set aside that order. Got it?
Yes.
It's fine. No representation on behalf of the petitioner on call part Mr. Ranjit Katunia, standing counsel. Department of Schooling. The order is at 11:0, an earlier occasion also petitioner remained unrepresented. On 11/05/2022, the court observed that if none appears in the subsequent call, adverse order shall follow on the next date fixed. In the interest of justice, matter be called on name. Matter be called on name.
Lordship, in this case, I will be led by Senior Advocate B.C. Datta, Lordship. Today we don't have the brief, Lordship. Can it be taken up after holidays, Lordship? We were not under the impression that it will not be called, Lordship.
Just
The Manoharan Committee.
lay for any other events without
Any other
lay for the
Lordship?
appropriate.
No, no, no.
Deeply on that, Lordship.
Applies because I am not taking this or for some other. Applies because I am not taking up this method or for some other reason. How many education councils you have?
Busy. In secondary and elementary, total 30.
How many of them are regular? How many of them are regularly irregular, and how many of them are irregularly regular?
Regular,
All are regular.
15, less than 15, regular.
Regular.
Regularly regular.
Regularly regular.
Yes, my lord.
Very good. From 10 to 4:30 or something else.
Almost, my lord. This is for different reason.
This petition was filed on 13th June 2013 by the petitioner Prabir Kumar Paul. Challenging the order dated 05/05/2013, whereby the 1104. Respond number 7. Was promoted to the post of vice principal at Government Boys Higher Secondary School, Haflong. Respond number 7. Sopon Kumar Bormon. Disregarding the claim of the petitioner, an assistant teacher with a graduate assistant teacher with BT serving more than 20 years as an assistant teacher at the graduate school of the state Government Boys Higher Secondary School. It is seen that while issuing notice to the respondents, report on 18/06/2013, observed that the impugn promotion to the post of vice principal of Government Boys Higher Secondary School, Haflong, of the respondent number 7 shall be subject to the result of present petition. From the annexes appended to this petition, it is seen that the date of birth of the petitioner was 1954. And as such, he attained the age of superannuation at 60 years on 21/10/2014. Further, retired from service in the attaining the age of superannuation at 60 years on 31st of October 2014. Thank you, Diabu. Just take it. Right. Amen.
May it please your lordship. Lordship, may kindly adjourn the matter for the day. Yes,
Here, may submit one thing, madam. Regarding this is old pension and new pension cases. There are hundred of repetition, madam. which have already been heard by a coordinate bench on this honorable court, my lord. And the judgment is reserved, my lord.
Please appear. Please, you're appearing.
Yes, sir.
What is your point?
Lordship, may kindly adjourn the matter for today. Lordship,
Why?
Lordship, in this matter, my senior KK Mohanty will be appearing, Lordship.
Yes.
Lordship, we are seeking coverage under the old pension scheme.
How come?
Since Lordship, we were appointed in the year 1999, and since then we have been continuously working. There was a break in service. There was no break in service in between. And we were appointed under the old pension scheme, but later on, when it was found that we were the genuine candidates, there was a batch of candidates.
Genuine candidates with regard to what?
Lordship, while we were working as assistant teachers, there were a set of candidates who were also appointed. And in the meanwhile, we were not paid any.
What was the direction of the Honorable Division? First, you please come to.
Page number 70.
Please come to the order of your learned single judge.
Page number 59, Lordship.
Please come to page number 58.
Lordship.
Read the second paragraph.
It is worth noticing that under Rule 3(6) of the Assam Elementary Education Provincialized Rules 1977, the selection board, after finalizing the list of only as many successful candidates as are advertised, vacancies with roll numbers and names of the candidates in order of merit, has to submit the name to the Director of Elementary Education, whereupon the Director shall authenticate and get the select list so prepared, published by affixing a copy thereof, and until the notice board of the Director of Secondary Schools, District Elementary Officer, Board of Elementary Education Officer, and District Inspector of Schools. And the appointments are to be made in order of merit from such authenticated select list. In the present case, none of the parties of the writ petition has been able to show as to whether any of the select list aforementioned was ever authenticated and published by the Director of Elementary Education Assam in terms of Rule 3(6) of the said rules. In fact, the government concedes that no records can be traced out with regard to authentication of any of the lists which form the subject matter of the present set of writ petition.
Now, the direction was given. Next page, in the circumstances.
In the circumstances indicated above, it is clear that until the time it is conclusively decided as to whether any of the three select lists which have surfaced in the present set of writ petitions is a genuine, correct, and legally valid one, and if so, which list shall be regarded as genuine, legal, and correct list, no direction for payment of salary in favor of either the writ petitioners or the private respondents can be given. The writ
Now,
petitions need detailed.
You can understand they will have to approach the civil, right?
Yes.
Now, please come to page number 72.
Yes. Shall I read it, Lord?
Please.
It is stated at the bar that the issue raised in this appeal was finally heard and decided by the division bench of this court in writ appeal number 9 of 2007, disposed of on 28/3/2007, including miscase number so-and-so, wherein some inadvertent typographical mistake occurred in the order dated 28/3/2007 were corrected with the order dated so-and-so, and in view of the same, it is submitted that this appeal may also be disposed of in the light of the above cited cases. Having regard to the orders dated 29/1/2007 and 28/3/2007, passed in writ appeal number 9 of 2007, respectively, and also upon hearing the learned counsel for the parties, we are inclined to dispose of this writ appeal, holding that the orders and directions given in the above referred case be also applicable in the instant case. It is ordered accordingly. The matter is referred back to the state authorities, particularly the Commissioner and Secretary to the Government of Assam Education Department, to look into the issues raised in this appeal and resolve the same in accordance with law. The entire exercise in this regard shall be undertaken and completed by the competent authority as mentioned above within a period of 3 months.
Now, page 79.
Yes, sir.
Finding.
Findings. The Commissioner and Secretary Education Department has issued order dated 18/1/2008 to comply with the direction of the Honorable High Court in the order dated 29/1/2007, passed in writ number so and so. At para 5 of the above mentioned order, there is mention of 2 select lists. At para 6 of the above mentioned order, it is stated as follows. As above, it appears that it is not possible to say for certain the lists are genuine, valid, and sustainable as per rules and procedures. Consequently, any appointment made out of these select lists also are not sustainable as per existing provision of rules. This is the considered opinion of the state government. The matter has been further examined in this department, and the Director of Elementary Education Assam was asked to submit a report in connection with writ appeal number so and so, Hasanbak Chaudhary and others. The Director of Elementary Education Assam submitted a report with a letter dated so and so. Shri Saidul Haq and 4 others submitted a petition dated 27/2/2008 to the Commissioner and Secretary, Education Department. And in the petition, the petitioners had referred the order dated 15/2/2008 of the Honorable High Court, passed in writ appeal number so and so, and requested for release of monthly salary of 111 stipendiary teachers appointed on 20/11/1999 and selected on 27/10/99. The above mentioned petition was forwarded to the Director of Elementary Education Assam for his specific views. The Director of Elementary Education Assam has submitted a report with his views that the list of 111 selected candidates can be treated as a valid document, and other lists not found in original cannot be treated as a valid document. It appears from the reports of the Director of Elementary Education Assam as well as the report of the Deputy Commissioner Karimganj that the list of 111 persons selected in the meeting of the subdivisional level selection committee, that is 27/10/1999, in which we are covered, in which the petitioners so and so are included therein. In the absence of the proceeding books of the meetings of the subdivisional level selection board, Karimganj, the list of 111 persons prepared in the meeting held on 27/10/1999 appears to be the only available reliable document to proceed with the proceedings of recruitment from the list. In the decision, in view of the above, the Director of Elementary Education Assam is directed to appoint the persons in the select list prepared in the meeting of the subdivisional level advisory board, Karimganj, held on 27/10/1999.
There was no record. The Honorable Single Judge found that the rule 32A should have been followed. It has not been followed. The government clarified before the court that there are no records available. There are various courts. Selection, select list, the proceeding book, all to be signed, select list to be signed by the chairman of the selection board. Then there will be subdivision level advisory board. Again, that will be signed by the concerned member secretary from the chairman. Right? There is a procedure by which the government constitutes the selection board. Already there, already specified in the rules. Now there are no records. A list was found out somewhere having 111. Then there is no finding on the report of the Director of Elementary Education that it has been signed by the chairman or somebody. But in spite of that, the Commissioner and Secretary has made a statement in the
That it is a
finding
valid one.
that this is authenticated by the chairman, but there is no report from the director in that regard. He said that this is the list available. There is not the list available. Whether it carries any signature or not, there is silent. And the commissioner secretary is also silent that this is the list, but only what is that this is the list found and has been authenticated. But the other provisions has been found by the Honorable Single Judge. That part of the Single Judge view, the observation still remains. But the government took a benevolent side. That is why I said appoint. That is why he said appoint. No records, nothing, a select list somewhere, unearthed from somewhere, without
Lord-
having proper praying that this is the director has, it should have been authenticated by the director. That yes, this is the particular list that came into this office and I have authenticated it, and accordingly it was notified in these places as per the rules. Forget the rule. Suddenly 111 names in a particular list in a particular meeting without being assigned by anything, no finding to that extent.
However, Lordship, in the second
That
last
is why,
paragraph,
that is why I'm saying, that is the reason, appoint. And you know appointment,
Lordship, we
you
have
have to
been,
clarify to that extent.
Lordship,
Yes.
Everything is there, you know,
Yes, my lord.
what is there and what is not there. Call it next time.
My lord, item number 4, my lord. She has closed the matter as infraction.
That's right.
But my lord, I say that my lord petitioner survives because I claim my lord notional benefit. And at one point of time, my lord, Mr. Yukener was requested to appear because the question was formulated whether 100% reservation is applicable to Dimao. And he was requested to assist the court.
Argu, second half.
Second half, my lord.
Where is the judgment of the apex court? Whereby that's a judgment rendered in the case of Mizoram.
Right.
Husband was,
Yes,
husband is from
yes,
northern India.
yes,
The mother is from Mizoram.
yes.
Son under the quota fought for his admission in the medical college as STH, being the son of his mother. When the Honorable Apex Court says no, it is the wife after marriage can become particular general category as per the wish, not compelled.
My lord.
But married to higher caste, the children born to them cannot have the benefit of the
Right, my lord.
other tribe. Right?
Right, my lord.
So here this Malavika Burman married to one
Tribal.
tribal
Oh, yes,
hills has become Long Mital,
my lord.
right? So become ST Hills. And
My
what
lord.
we have noticed is that you have obtained certain information through RTI.
My lord.
And also it is a thing, your name was there in the list.
My lord.
You have not challenged that list, showing that Longmai as a scheduled tribe. You said that she should be considered a scheduled tribe plains. Right?
My lord.
But she was. But after her marriage to a hills,
My lord.
what will be her district? That's
My
why
lord,
you are
if-
asking you, where is the judgment of the apex?
My lord, if I'm not wrong, my lord, to say that, my lord, decision of the Supreme Court is to the extent that
There are subsequent decisions are there.
yes, by virtue of marriage, my lord, one cannot
Change
acquire
her
this status.
status.
He cannot change her
That
status
is
or
was
his or her
clarified. Clarified.
My-
Right?
My lord.
Clarified because there are two things. One is for the service,
My lord,
for the purpose of service taking benefit.
my lord,
That is what the Honorable Apex Court has differentiated.
my lord.
But if somebody, because of the judgment of the Mizoram case, it is very clear
Yes,
that the children born to such and such will be it is general, not from the mother's side.
my lord.
Right?
Right. My lord, in that case, my lord, perhaps, my lord, say if father and mother belong to different, my lord, caste, then, my lord, it is the option of the children to adopt either of the,
If
my lord,
it
caste
is
of the either
two
of the.
different caste,
Yes,
but if his one is general, then the other is reserved,
yes,
then the
Then, my
children
lord.
born to them will become general,
Yes, yes,
not
yes.
will not become the
Yes.
caste.
but in this case, my lord, one is STP, another is ST Hills. Roster says first post is reserved for STP. Therefore, post is filled up, was filled up. Then again, they, my lord, appointed STP. But
But
Malavika,
that decision, otherwise this is subject to that particular lady who marries the other caste.
my lord,
It will be up to that lady to decide whether she will continue with that category or will accept the category of the caste of her husband.
my lord, I will find out that decision, my lord.
You should,
My lord, Roshima can fix.
because your claim is that she was STP.
Yes,
Married to an STH.
yes, my lord.
So she cannot be
She
considered.
cannot,
under
my lord,
the
convert it,
STH.
yes. My lord, I have gone through that decision, Lord, she has rightly pointed out. And one case from Meghalaya, my lord. In that case, particularly, ultimately Supreme Court held that if the child is, my lord, born in a particular caste, but he followed the, my lord, custom of different community and brought up under the different community by following the custom, etc.
No,
etc.
that
In
is a
that
clear
case,
case because that was a case from Meghalaya also.
yes,
You can
Meghalaya
see
also.
It was taken a decision by the government. Normally, it's in Meghalaya, it's a matriarchal.
Yes,
But the lady from the Meghalaya got married to someone from the
yes,
northern Indian part.
my lord.
So it was not a matriarchal family.
My lord, I will, my lord, bring the judgment on Thursday, my lord. Huh? 9. And that was the reason, my lord, court has, my lord, sought for assistance of senior advocate, Mr. Nair.
Is he available?
My lord. Earlier also I talked to him, my lord. Huh? Today I couldn't, my lord, meet my lord. And another question is, my lord, whether 100-point roster or my lord, reservation policy will have any application in 100%, my lord, tribal state or tribal autonomous council. There is another question raised by the.
No. Roster point has to be, because there cannot be single roster here.
Yes.
It has to be.
Because the order reflected, my lord, this is
Only
reflected in-
pursuant to a decision of the Honorable Apex Court.
Yes, my lord.
Recently, there was a proposal from one of the hill state to us
Yes, my lord.
for reservation of their all posts. But one of the hill state claimed that all posts should be.
Are to be reserved for them, yes, yes.
We said, no, the constitutional provision is constitutional
My
provision.
lord,
We
my
cannot have it.
But in my understanding also, my lord, roster will have the application.
Roster has the application.
Have the application. I'm obliged to your
There
lordship.
cannot be 100% reservation.
Yes, sir. 100% reservation is not constitutionally. my lord.
Reservation is always there, 50-50.
Yes, yes.
In that.
Yes, sir.
Placed on 9.
My lord. I will inform Mr. Narman.
The name of Mr. UKNL and its senior counsel. Who is that, Mr. WPTPC?
Art formal.
Art or senior counsel WPTPC. Who is representing Diva Hatao?
Him also earlier, Mr. Goswami.
No.
Goswami now cannot.
Very recently appeared.
R Das, Ranjan Das. RJ Das.
RD Das, K. Konikot. A. Konikot.
My lord.
Sending counsel Dima. Verma Burwa. Mr. Patna Riol. But this carry forward is a system, we always do it, because what happens, we are not getting candidates in the judicial service. from the ST hills.
That is permissible to some extent.
Every year it has to be carried
Yes, yes.
forward. If you are filling up the post by
Yes, yes.
reserve category, other categories, then that particular post needs to be carried forward.
You know, in that case, my lord, a candidate was available. But he was not given the opportunity, my lord, given any opportunity.
This post falls under which vacancy? Which vacancy, roster point? Which roster?
My lord, initially,
Position.
Initially, my lord, 2005 roster.
That's fine. Position number what? This particular post of vice principal. Serial number what on the roster? 100-point roster.
I'm showing you, lord. And at page, my lord, of annexure K, page 107. That was the original roster.
Which?
Vacancy, first vacancy reserved for STP.
We are asking you.
Yes.
The petitioner is claiming, right?
Yes.
That he comes under unreserved category.
Yes.
What is the roster point?
Roster point is, my lord, fourth.
Cannot be 4.
Unreserved fourth. First one is STP, second one is OBC, third one is SC, fourth one is unreserved. Fourth, fifth, sixth unreserved.
No. There are 2 high schools, government high schools, right?
Yes. And 2 community schools are combined seniority.
Where is the seniority list?
Seniority list I don't have, my lord. Because they in their affidavit, they said I am the senior most. It was admitted by them. Affidavit in opposition. Modify to. My lordship may kindly see annexure R at page 33 of the affidavit in reply. I have given a list, madam. At page 33.
Your post comes under 14. 14 is unreserved.
14. Four, 5, 6 also unreserved, my lord. Unreserved. Continue. देखिए 14 क्या करते हैं? Okay. 14 on period. Then 18. Then 20. A whole position.
Fine. Fine. Hearing concluded.